Welcome, everybody. I'm glad you guys are here to Decolonizing Reasonable and Active Efforts and How. And so we're going to have a conversation here. We'll do some quick introductions, and then we're going to hopefully engage you, hopefully give you some good content to think about. We do want to move your minds and your heart. So hopefully we could engage you in those types of ways. But first, before we get rolling too far into this, we do want to do some quick introductions. Sabrina, is it all right if you introduce yourself first, and then I'll introduce myself and I'll roll into the beginning? Okay, great, go ahead.
Sure, that would be speaking if you all would just introduce where you are calling in from, and also honoring the Indigenous land that hopefully you looked up earlier today in the chat box. And if you have any other comments to say, of course, we'll love to see them. So I'm Sabrina Alaguire, and I'm the co-founder and co-executive director at East Bay Family Defenders. We are a relatively new family defense practice. We opened our doors September 1st of 2018, and we are growing and evolving every day. I am really grateful along in my career to have been able to sometimes indeed have ICWA cases, and very happy to have met Sheldon in the process of planning this, and to have been connected also through other folks we've worked with. So we are hoping to really present a thought-provoking workshop for you today. It really sticks to the description a lot, what we're doing. So let's roll up our sleeves and figure out what we can work with that we've got, and what we could imagine for deconstructing and decolonizing and reinventing a future that is more just.
Thank you, Sabrina. And my name is Sheldon Spotted Elk. I'm a Northern Cheyenne tribal member from Lame Deer, Montana. This nice picture that you guys see on the opening screen of our PowerPoint slide here, that's Lame Deer, Montana. This picture was taken by my cousin sister, Diane Spotted Elk. She's a tribal council member and also has just a beautiful eye for art. And look at that picture. So we're traditionally speaking, we are tribes that valued family. We're tribes that valued kinship. One thing that I always like to say, and maybe this is my centrism coming out, but I think Indigenous peoples, especially Native Americans here and American Indians here in the United States, we could teach the world about two things very right now. We could lead the world's conversation in environmentalism, and we could lead the world's conversation in love, very specifically kinship love. So we know about family, we know about connection, and so that's some of what we want to talk to you about today. I do want to acknowledge that there's some irony in our title. I realize that. How do you decolonize something that is just so in-depth in colonization? How do you decolonize it without losing it altogether? At what point, when you remove an element of a mousetrap, is it not a mousetrap anymore? You know, and so that might be some issues that we're talking about right now. And if you have some comments on that, please share them in the chat box. I appreciate everybody using the chat box right now. With that, I have a pop quiz for you guys. We're going to go through a couple of questions, and I'll tell you right now. So if you get 5 out of 5, there's 5 questions here. If you get 5 out of 5, I'll put my email address in the chat box, and send me an email and say, hey, I got 5 out of 5 on that pop quiz. And I'll send you a Starbucks coffee card. And so you could be the big winner. So this is kind of tough. Some of the questions are pretty tough here. So if you get 5 out of 5, it's multiple choice. Please use the chat box. And so it's, you could just put A, B, C, or D, whatever you think the answer is, in the chat box. So so we'll do that, have 5 questions, and then we're going to get onto some content and hopefully have a good conversation about this as well. And we hope that you interact with the chat box as much as you possibly can, and the questions. So great to see some of my friends that are on here. So if we go to the first question, we'll jump right in. So we're talking about the Declaration of Independence here, not the Bill of Rights or the U.S. Constitution. We're talking about how does the Declaration of Independence refer to American Indians? And so is it A, merciless Indian savages, B, as native inhabitants of the land? It does not mention the existence of American Indians, or is it D, none of the above? And so if you put in what you think the answer is, or if you know the answer, put the answer in. So I'll give you guys a couple of seconds we'll give you about 20 seconds to get the answer in. So stay close to your computer. So we have a lot of C's in there. It doesn't mention American Indians at all. We have a lot of C's coming in right now. We have an A, a couple of A's. I know those two people that have the A's. So we'll wrap up. We'll go to the answer in, give you a couple more seconds. 3, 2, 1. Let's go to the answer. So the answer is A's. Whoever put A's in there, and I know you guys had cheat codes. You guys are American Indians, and so you knew how they mentioned us in the Declaration of Independence. And so it says, in the full context of this, one time at a conference, I presented this and I gave the answer, and somebody said, "No, that's unfair. You took it out of context." Here's the full sentence that it's in. The merciless Indian savage, whose known rule of warfare is an undistinguished destruction of all ages, sexes, and conditions. You could see the prevailing attitude about American Indians at that time. Actually, this whole session could be about founding fathers and their attitudes towards American Indians and colonization. When we talk about colonization, we talk about these guys, that the founding fathers, and so here's their attitude, prevailing attitudes about American Indians as uncivilized. And so we see this. I like one of my favorite presenters that I always see is Marty Guggenheim, and he talked about the family regulatory system. That's been occurring to American Indians for 202 years now. So the first explicit act, and of course before that, there's a big history on this, and I probably could put that resource in the chat box. There's a good law review article by Matthew Fletcher about this. But the whole basis of America is about stealing land and stealing children, indigenous land and indigenous children. Explicitly, Congress passed an act called the Indian Civilization Act, and it was aimed to civilize, giving money. It's very simple. We're going to give money to churches, and they're going to do civilization. This turned into the boarding school experiment, the project that happened with American Indians, and hundreds of thousands of children were impacted and scarred by that. I don't know one American Indian that doesn't have a relative that went through the boarding school experience, and so impacted all of us. I've yet to meet one person that doesn't have a relative that went through the boarding school experience. But even most recently in 1950s and all the way up, we still experience disproportionality in the system. But in 1950s, Child Welfare League of America had federal funding to do the Indian adoption project of getting children off reservations and adopted into non-Indian homes in the suburbs. So this is still alive and well. So we'll go to question number 2. And so this question, we're talking about genocide here. So the Holocaust of World War II is not only one of the most tragic events of the 20th century, but of modern history in general. Close to 6 million Jews, and that's nearly 2/3 of all European Jews. What a devastating atrocity. And many other people perished. We know that other peoples were targeted during the Holocaust by Nazis. By comparison, approximately how many American Indians in Americas died within a century of Christopher Columbus's arrival? So from the late 1400s to the late 1500s, what are we looking at? Is it nearly 5 million, which would be half the existing population, nearly 10 million, roughly half the existing population, nearly 10 million, 95% of the existing population, or are we going 100 million, roughly 95% of the existing population? You have a lot of D's coming in. I'll tell you, this number used to be controversial, but it's not controversial anymore. But maybe 20 years ago, there was estimations of how many American Indians populated the Americas, how many indigenous peoples populated, and it just kept on growing. So this is not controversial at all. We could go to the answer. And so it's D. Good job. Those that put D, I saw a lot of people put D, so good work. So within first generations of encounters, we had war, we had disease, we had explicit acts to bring heads of leaders of tribes. And so this act of genocide ranks among the largest acts of genocide in the history of our world, of civilization, if I use that word back. So that's one of the biggest acts of genocide ever. So it's atrocious and gross. Let's go to the next question. I appreciate you guys engaging this. I've always wanted to be like a talk show host that hosts a game show, so that you guys are letting me indulge myself here. So thank you. So when we're talking about foster care, we're talking about children in foster care. When we look at what that disproportionality rate would be, what is that rate? And so one would be, it's exactly, there's no disproportionality. The population in foster care is an exact match of children, American Indian children under 18. And then it would go up or down from there if there's no disproportionality. So what is that rate? Is it A, no disproportionality? Is it times 16? Is it C, 2.66? D, 3.18? And so I like that. Once again, Marty's presentation, he mentioned that Mother Jones article, and they explicitly mention Black youth. The article was about Black youth, but they also mentioned American Indians in California that were born in 1999. Half of us were investigated by CPS. So I appreciate you guys. We got a lot of B's coming in here. A lot of B's. And so this is coming off where my source is here. It's the 2018 AFGARs. So this is where this number comes from. All right, we'll give you a couple more seconds. All right, we'll jump to the answer. The answer is C. And so I saw some people put down C. The people that did put down A, and I actually have the incorrect, it was times 16 for Minnesota. Minnesota has the highest disproportionality rate. And so some of our people that are calling in from that jurisdiction, you have the highest rate of disproportionality of American Indians in foster care. There's plenty of other states that are doing really, really bad. Of course, the Mother Jones article mentioned that half of all Black and American Indian are subject to CPS investigations. We look at Black children, they represent 1.66 disproportionality. But when we look at the total children in foster care population, that represents over 1/4 of all children in foster care. So this is a devastating thing to think about. So it's really, what can we do about that? I want you guys to think about that. It has something to do with the way that we do representation, how we show up to court. But I want you guys to be thinking about that as we go through this presentation. So let's go to the next question, please. All right. How many federally recognized tribes? And so how many tribal governments? And so that's what we're asking. How many tribal governments are there in the United States that are recognized by the feds? So is it 55, A, B, 230, C, 574, D, 1,123? Yeah, put your answers in. Another little fact I'll drop down. I do a lot of work with tribal courts. I failed to tell you what I do, actually. So I used to represent children and parents in foster care, but now I consult with courts, and I do a lot of work with tribal courts. And so there's about 400 tribal courts out there, and almost all of them do child dependency within their jurisdiction. Other courts do other things, of course, but almost all 400 tribal courts out there do child dependency work. And that might give you a tip of how many tribes are out there if you listen closely. All right, I see some people they're getting the right answer here. So if we go to the answer, there is it's C, 574. So you think about that, one time there was 300 different languages spoken by tribes in the United States. There's only about 175 that are spoken fluently today. Unfortunately, it's really, and I'm part of this, it's unfortunately my dad, fluent speaker, probably didn't speak English until he was 5. Probably wasn't around white people consistently until he was about 5 years old and had to go to school. And I only speak a little bit of Cheyenne. I know some words. I know some greetings. I know a lot of swear words. That's all I know. I'm part of this and how devastating it is. And actually, if my dad was on this call right now and he would tell you about his boarding school experience, I think he softens it up for us. He tells these stories and he kind of tells them as a funny story, but there's a lot of pain behind the fact that they'd put soap in his mouth when he would speak his language, and he didn't know how to speak English. But so when he would try to communicate with his friends, it was only in Cheyenne, and he would be punished for that. And so and he tells it as a kind of a joke, but there's a lot of pain behind that as well. And you can see the implications. My oldest brother kind of speaks, but the rest of us don't speak very much Cheyenne. So go to the next slide. And this is the last one. So if you're 100% right now, good work. So here's the last slide right here. So of all major racial and ethnic groups, which one lives in the most residentially segregated environment? Is it A, African Americans, B, Hispanic Americans, C, Asian Americans, D, Native Americans, or is E, none of the above? And so some of us that know history, know the history of redlining and reservation systems, we might know this. I'll give you guys
a lot of D's.
Yeah, we're getting a lot of D's here. A lot of Native Americans.
Some E's.
All right.
Ready?
Yeah, we are ready to go. And I'm sorry to you guys because this was a trick question.
Oh, who's going to get that gift card from Starbucks?
If you got it, good work. I'm sorry that I did a trick on you guys. So if you ever see me, say, you know what, Sheldon, you owe me a cup of coffee. So you tricked me, you bastard. So the answer is E, none of the above. White people are actually the most residentially segregated population. And so that's something to think about. And when we talk about anti-racism, I think some of the struggles that our society has, that the white community has, is that sometimes they don't know diverse experiences. And so it's rare that they interact with diverse experiences on a consistent basis. Very few have been to reservations and tribal communities. And when we look at the tribal population, 2 out of 3 of American Indians, including myself, we live off a reservation. I live away from that beautiful picture that I showed at the very beginning of my tribal community. I live in Denver, actually, is where I actually reside. And so that's where most of us live, is in cities, which means we live in state jurisdictions that the Federal Indian Child Welfare Act, which requires active efforts, applies. And you might be representing, and some of you have, American Indian children and families in the court system. And there has to be some sort of cross-cultural dialogue oftentimes with a lot of your representation. And so I do want to talk a little bit about that and how we could get the most out of that active efforts finding and that reasonable efforts finding as well. So if we go to the next slide, I think maybe I have one last thing to say, and I'll hand it off to you, Sabrina. Or did you have anything to add?
You know what? Hold on. I just have to unhide that slide really quick. Whoops. You can see in the editing back room right now. Unhide that slide. All right. There we go. And back to you. All right. Now I got this.
Nice. And so when we talk about, and I love this quote, and I'll just leave you guys with this quote, and then we'll have a conversation. But it's something to think about, is that I think coming from the American Indian perspective, this is a quote by an Indian educator, Maria Cromwell. And so she's talking about how to create change. And so if we were in person, I'd have made us all yell out, "I'm an agent of change" at the very beginning, and I'd have made you guys say it back as a callback, because I feel like that's what's requisite in our advocacy and the work that you and I do for families and for children and for communities. And so creating change is uniquely different for American Indians. For to do so, American Indians must articulate the problem to others who rarely share a similar experience or look at the problem in a similar way. Thus, American Indians trying to create change find themselves in an untenable position of always complaining about something. As a result, when American Indians raise their voice to draw attention to problems which need solutions, they find themselves the target. They become the problem. And we could see this most recently. Well, I probably would cite something even more recent, but we see it nationally. We saw it with Standing Rock and the protest up there for clean drinking water. We just want clean drinking water. and us raising our voice against that became a national issue right there, and had cops spraying us with hoses, so there's some significant issues about that. And so us as advocates that have opportunities to represent marginalized people, marginalized populations, how do we show up? What tools do we need? Something to think about. So good. I'll pass it on to you, Sabrina, while I grab a drink of water here.
Sounds good. Thank you, Sheldon. So yes, we wanted to really ground this presentation in our own bodies and our own communities, our own homes, our own families, our own selves. And so much of the process of being able to walk through this work every day is to indeed keep personally evolving and challenging ourselves and seeing more and more of the oppression that is often denied or not spoken about. So the first slide I'm going to cover is really just about the definition of decolonization, which I see as so similar to work that many of us are doing to understand white supremacy culture and policies and practices, and have appreciated how much diversity, equity, and inclusion work is really more and more pointedly identifying how white supremacy culture is the predominant majority way in this country and in our communities and in our organizations and it personally. And so if you've been versed in that, that's a helpful lens to also bring to thinking about decolonization much more historically, that decolonization is the process of deconstructing colonial ideologies of the superiority and privilege of white Western thought and approaches. And so we both look at ways that decolonization means us actually dismantling these structures that perpetuate this status quo and the unaddressed power dynamics that often get denied or justified in various ways, in racist ways. And on the other hand, it involves valuing and revitalizing and getting in touch with Indigenous knowledge and approaches and weeding out the white supremacist and settler biases and assumptions that have completely permeated our beings and our communities and our legal system and the child welfare system in particular. So we're going to just kind of first take a deep breath. We're going to take a deep breath in that because this has been a lot of also like trauma that we've gone over, and the most devastating genocide in history in the world has been on the land in which we stand. So that's a lot to stay grounded in, and especially when you all are fighting the really hard fight every day. So we just want to take a big breath, hold you in that space, and hopefully instill courage and bravery and inspiration that you all are champions of something that is so important to do. And so to the extent that what we're going to talk about today feels like it equips you for that, we want to get there. So questions for reflection that we would like for you to enter into the chat. So first is, what motivates you to decolonize this system? If you could just go ahead and enter into the chat. What motivates you to decolonize the child welfare, family regulation, juvenile court system? Why do you want to? If any of the reading about decolonization spoke to you, why would you want to take action in this system? Thank you. 900 arrests at Standing Rock and Standing for Clean Water. Faith. And depression for all people. I'm entering one too, just to help My love of my family and tribe, justice, my clients, a belief that children belong with their parents, love and hope. Oh, I'm having a hard time reviewing all of them. Sheldon, can you help me? I'm having a hard time seeing.
Yeah.
Help children escape, equality,
Uh,
desire to eliminate systemic bias and keep families and cultures whole. I don't believe the government makes a good parent and children do better with parents.
belief in
The inequity of structural system. Sorry, go ahead. To help others avoid the disconnect I have from my native heritage. Did I miss any, Sheldon?
Yeah, there was a couple. One, let's see, don't believe the government makes good parents and children to do better with their parents. Young adults, and I think that's yours, young adult, homeless adults. So after years of painful separation, they come back home, right? So
keeping cultures and families strong. And I think that's supposed to be united, or it could be untied as well. Oh, united. All right. Love prevails. Love it. Thanks. So then let's do the second question. What are we changing about the system? What are you seeing that you do that is changing the system? Just want to also note, a person raised in the comment, the family regulation system is an extension of slavery. One of the cornerstones of colonization is family separation. What are we changing about the system? That's the question.
holding system accountable, bringing humanity to an often evil, destructive system, understanding that belief systems and child rearing can be different among cultures, and the government does not set the parental standard. Wow, good one.
What are you changing about the system?
Like, there's a lot of humanity. I like the human-centered comments that are really in here, powerful. Empowering parents with their parental responsibilities with appropriate supports, like it. Parent voice matters.
I'm just putting stuff in there to try to help. Okay, you don't need to read mine.
Giving a voice, good stuff.
So what do you think that advocates need to move forward? What do you need to move forward? Oh, I love this last one about what you're changing in the system. Being brave in court, raising issues, not backing down, even when the judge is telling me to shut up and sit down. I'm getting families back together over the state's objection. So what do you need to move forward as an advocate? Oh, I don't know that I am changing anything, but I am fighting for my clients to be treated as real people and not statistics when I am able. I'm doing a lot of talk, but little action at this point, at least trying to lead by example to treat people with humanity. I just really want to honor those comments, you all. And that's a lot of the work. What do you need to move forward? It's the next one. I appreciate so many more comments that came in about what you're changing. So a lot about needing more resources, encouragement, stronger voice in government. This is what you need. The system is an illegitimate system. I am motivated by my clients who will heal themselves and their families from intergenerational trauma. Need replacement of institutional actors. We need judges who are willing to challenge the agencies and actually apply the law. We need to change people's minds. Sheldon, can you help me? I'm a little behind.
Funding for zealous and multidisciplinary family defense. Oh man, I'm way behind now too.
I know, right? Folks can be looking, please be looking through the chat yourself too, because we're having our time keeping up.
The history of racism, and we need to be brave. We don't need to be perfect, but we need to be loud. That's a good point. We need laws to change and recognize family realities. We need there to be more cultural awareness training from top to bottom, police, investigators, caseworkers, judges, attorneys, especially in rural areas. Easy access to studies that will help show my clients should be with their children and families.
We need to know history of racism. We need to be brave. Don't have to be perfect, but we have to be loud. We need laws to change to recognize family realities. We need judges who listen and don't just rubber stamp. I'll
tell you, I'm really sad that we're not together right now. I'm getting all this good energy, and it would just be amplified more if we're all in the same room. So I appreciate it.
I really miss seeing everybody. All right, this is really amazing. We need respect for all family structures and acknowledgement of racism, poverty, genocide, and colonization. We need space to hear and listen to parents and families. Thank you, everybody. If you're having more comments, please do put them in the chat so that folks can reference those. This is really, really lovely sharing. Okay, so we're gonna just try to keep on track. So we wanted to just start with looking back at the history of where the standard of reasonable efforts came from, that Marty did, helpfully talk about in the opening plenary. So reasonable efforts was really intended to be more than a box to check, if we give the folks credit at the federal level who were bringing this about, and the standard of agencies being required to provide reasonable efforts to prevent the separation of families, to prevent placement of children in foster care, and also reasonable efforts to reunify families safely, were really articulated in the Adoption Assistance and Child Welfare Act of 1980. And so just want to point out that during the hearings, there was an acknowledgement that far too often foster care was used as the first option when a family was in trouble, and that the new provisions would require states to examine alternatives and provide, whenever feasible, home-based services that would help families stay together or help reunite families who were separated. And so it was really intended to be a way of preserving family integrity and shifting removal and separation into a last resort effort. We sadly have seen that there are so many challenges in getting this standard to have teeth. However, we do want to give some credit to where the intention came from for this standard, and what folks may have been able to do, what advocates may have been able to do with this standard up until now, before we completely question deconstructing the whole thing. So bear with us. So, Judge Lynn Edwards has written extensively about reasonable efforts and has been a real proponent of advocates really arming themselves with full understanding of the legal framework of where to invoke the reasonable effort standard, and really demanding that agencies provide responsive and effective services for families that would assist them with reunifying or would prevent separation of children. So this is a quote from him, that reasonable efforts, or in particular, no reasonable efforts findings, are the most powerful tools that juvenile court judges have currently at their disposal, independent, and that we should all, of course, pay special attention to whether and how the agency is doing their job. Sheldon, back to you.
I'll just say one last comment about the previous slide. You could leave it here, though.
Yeah.
The previous one before that even, but you could go back to the slide. But when we look at how white supremacist the system is, though, and so if this is our tool right here, and I just want to be critical just for a second. So this was passed in 1980. ICWA was passed 2 years before this. And so the Indian Child Welfare Act, which those that are familiar with the law, it requires a higher standard than reasonable efforts. It requires active efforts. this law failed to include active efforts. And so reasonable efforts findings connected to drawing down Title 4E dollars. So in all reality, a judge could get the law wrong on an Indian child and make a reasonable efforts finding, which is an incorrect finding under ICWA, and still draw down Title 4E. So they forgot about ICWA. And so that's just kind of the irony of that is painful to me, that we're forgotten again. Indian people were forgotten one more time, right 2 years after we passed our Landmark Act. It's already being missed from this provision here. So something to think about. The last thing, and we could go to my slide that I was going to talk to you about. I do a lot of work with judges. And so new judge gets on the bench. He's recently called. I won't tell you what jurisdiction he is. Probably he might even be on here. So, so he's brand new to the bench. His whole career, he practiced criminal law, like never been in child dependency, which we know is not, this is status quo almost all the time. Judges come from other disciplines. And so this judge didn't really know too much about child dependency. And he asked me a question. He's like, hey, Sheldon, what if I don't find active efforts? What happens if the agency doesn't carry their burden and I don't find active efforts? What happens? Do the children go home? And no, the children don't go home. They lose. What ends up happening, well, if you don't find reasonable efforts, they lose out on Title 4E. I know in a lot of jurisdictions, and I've talked to Lynn Edwards, I've talked to judges. I know this is a powerful motivator, and I don't hopeless because I feel like this is a tool. We need to use this tool. But it's the contrary to the welfare of the child finding that is the child goes home finding. If you want to attack that and get children back to their families, that's the finding that we need to attack, not the funding mechanism. But in most courts of law, we think about that. In most courts of law, in most issues, if you as the petitioning party, the moving party, do not carry your burden, in most instances, that means your case is dismissed, right? And so, but child welfare is, of course, this unique thing. And I think we as advocates, we need not only to be advocates or lawyers, we need to be lawyers plus. So here we have ICWA, which is called the gold standard of child welfare, and which is the irony of it not being included in the Adoption Assistance and Child Welfare Act, the active efforts finding. But the reason it's called this is that I like this illustration and this is what when I hear of ICWA or I think about why it's the gold standard. I think of this illustration that I made here, these concentric circles, and children that grow up in those concentric circles, they're resilient. They have resiliency in life. We know that life's winds will blow and that storms will come. And it's resiliency that keeps us grounded, that makes us feel connected, that makes us feel loved and able to give love. And so we will fight with active efforts. We'll hold the agency to that accountability to keep them safely with their family. Of course, if that's not possible, we're looking to relatives. ICWA was so vanguard when it was passed, no states had kinship finding requirements. Today in 2021, 48 out of 50 states have kinship finding requirements. And then all this happens within a cultural and a community context that children that for no fault of their own, if they're removed from their home, they should have their access to their friends. They should have access to their community, to their school, to their baseball team. So we need to fight for that. It raises resilient children, connected children. And so that's what we're looking, that's why it's the gold standard. If we go to the next slide. And I like this slide right here. I love, and so this is me and Bert Hirsch and Jack Trope's in this slide as well. So Jack Trope and I, we were in New York City, across the street from NYU Law School. There's a cool cafe over there. We met Bert Hirsch, who's one of the 3 lawyers that put pen to paper and wrote ICWA. And so it was one of those things. We met for lunch and it ended up being dinner. So we were there for like 6 hours. He told us all these cool stories about him representing tribes, him representing families, and east to west, north to south, Alaska to Florida. He was all over, raising hell. And he asked me, Sheldon, do you do ICWA trainings? And I say, yeah, at the time I did a lot of ICWA trainings. Yeah, I train a lot of people. Yeah, I do it all the time. He's like, well, you need to start telling people that law is the only reparative law in the books. It's written from that perspective. You look at the congressional findings, it's explicitly written for that perspective. It's written to heal families. It's written to heal the past atrocities of the United States of America. It's written to address those things. But I like what he added to this, and I'll remember this forever. He says, but after all, ICWA is just bleeping. He had a poetic way of just dropping the F word into things he would say. It's just effing words on a paper. It takes people working together to reach its highest aspirations. It takes collaboration. I like the comment in there about more funding for multidisciplinary representation. I think that's what it takes. I saw another comment in there about how can I explain to the tribes that the children were safe, that there was no physical harm present. Building relationships with tribes. There's so many positive outcomes that come along with that. And so building a relationship of trust, much like you need with your client. Of course, the tribe is not your client, but building that relationship of trust is a big thing for you. It's going to get better outcomes for your client, for your parent that you're representing. So those are all aligned with what Bert's saying, so it's more than just the black letter law on the paper. We go to the next slide. And so here's some examples. And of course, if there's reason to know or reason to believe that your client, the child involved in the case is American Indian or has the ability to become a member, and one parent is eligible for membership or is a member of the tribe, they should treat that case as an ICWA case until it's found out it's not, until that finding is made. And so you are asking for active efforts. You're asking for this higher standard of active efforts. We're asking for the agency to have more engagement with the parents. So not just referral to services, like here, call up these guys for your drug and alcohol assessment. Actually, the agency working with that and calling the people that perform the assessment, or even providing transportation, so that's explicitly bringing up. So it's beyond, it's plus. Len Edwards the judge that she quoted, he does make a lot of comments about it. It's above, this is above reasonable efforts. It's one step above. And so that's what the very English definition of active is. It's more than reasonable, so we're trying to get above that. And so culturally relevant services, it's about connecting families to services that are actually going to speak to them. And so next slide, or do you have anything to add to that, Sabrina?
Yeah, just that, I think that obviously this begs the question about how much we can actually transform the reasonable effort standard to start to approximate the active effort standard and even raise the active efforts standard as well. And what we see so much in our work is that, like Marty pointed out in his comments, that, handing an ineffective referral to a parent can be found as reasonable efforts. And that obviously, bringing evolving case law and bringing these kind of issues up on appeal, I think especially with more heightened public awareness, which is increasing about the injustices that happen in the system, that perhaps we can see that this standard can be improved and better implemented in the meantime, while this is, in a lot of ways, some of the best protections we've got. And I don't know if folks have anything in the chat to kind of reflect on about this, but, obviously this is I think it's just also like a painful subject, right? Because seeing the low level of what is seen as acceptable for agencies to provide to families has been one of the bigger areas of just, complete lack of help and hurting of families in the system. So, and also, what we'll talk about is, can agencies actually provide help when the real reasons that most families are in this system have to do with the conditions of living in poverty? And so, but even within that lens, could we do more to creatively litigate and insist that agencies actually be helping to alleviate those conditions of poverty and decenter the focus on individual blame to more looking at systemic causation? So I will just go on to this next part now, but then we do really want to get to the discussion, so I'm going to kind of zip through it. And Sheldon, if you can help me if there's comments in the chat box, that would be good for me to pause and address. So we just wanted to kind of point out, especially, there's a variety of experience levels in the room. I know we have some of our newer attorneys here, and for some of the more experienced, seasoned folks, this might be something that you just know. But we wanted to talk about where the reasonable efforts and active efforts findings are required. And so obviously at the detention phase or at the shelter hearing, there is the need for the agency to show that reasonable or active efforts were made to prevent removal or separation of the family. And so the consequence of that would be, after that initial emergency hearing, that there, well, in some states, the consequence could be that that standard is so embedded in the standard for removal that the children should go home. It obviously depends on the interpretation of both federal and state law in regard to the findings being necessary to justify separation of the children from their home. But also, agencies do run the risk of not getting Title IV-E reimbursement for that initial stage of the case. However, they have 60 days to cure that, which usually happens by the disposition phase, and gives the agencies more time. So not as much accountability there. The question is also asked at the disposition phase in very similar ways, and potentially with similar consequences depending on the jurisdiction and the judge. So then let's look at the next stages. And so we all know very well that reasonable or active efforts are required to be shown at review hearings, and in particular to return children home or reunify the family, if that is still the goal of the case. And so in terms of accountability, there's, of course, the funding accountability again. That, in both under the federal law and under state law, that a complete absence of any reasonable or active efforts findings could prevent or delay the filing of a termination of parental rights petition or the ordering of termination of parental rights. Of course, unfortunate that you have to completely get the no reasonable efforts findings at every stage. But nonetheless, here's what we're working with.
There's a good comment in the chat box, and I think it kind of illustrates this, and maybe gears our advocacy. It talks about it's like giving someone a list of apartment complexes and saying that's enough to satisfy reasonable efforts. So like, here's some apartments, go check it out. Of course that does not. And a lot what Len Edwards and actually David Kelly and Jerry Milner, their administration, they really focused in on making reasonable efforts count. I think as advocates, standing up in court, making some noise on that, making some noise, getting off your hands at that point, and making a motion there, stopping the courts, putting a stick in the spokes of justice, if you will, right there, and saying, hey, slow up right here. Let's make this count. It's as opposed to just rubber stamping reasonable efforts. And that's a lot that is a tool. That definitely is a tool.
Yeah, and I just want to also point out, that the rates of disproportionality for Black children in foster care have been getting to be, somewhat similar to what the rates of removal were for Indian American children when ICWA was passed. And so, there are definitely, I think, a lot of arguments about why active efforts should be applied, in particular to Black families, and that I noticed in the chat that active efforts should be required for all families. So this is also this area where our standards of law are so much lower in this field of law, and so much work that we have to do to really raise the bar to provide genuine legal protections for families. So anything else there? Good. And yes, that, I also, right, this whole issue about how courts become the guardians of the funding for agencies. And I know during the pandemic, that was definitely on the minds of our court around making sure that the agencies didn't miss their deadlines to be able to get all of their funding, and a lot of pressure on our attorneys to agree to reasonable efforts findings so that the county funding wasn't jeopardized. So that may have been the pattern for a number of people, and especially in this past year where so much court was paused or stopped. At the same time, it can be a meaningful consequence, but having jurists who have the tenacity and courage to hold the agency accountable is obviously key. Okay, so now we're going to get a little bit more into the discussion, and I searched for a photo that might be like a Rorschach test for this next part of the discussion, and I found one. It's a tattoo design. It's from a tattoo artist, and I would like people to enter into the chat what comes to mind for you when you see this picture. I'm gonna try to view the chat. I mean, in the context of your work in particular.
I was going to say it looks like a really cool heavy metal shirt.
Okay. Well, I will just say that I was trying to figure out how to depict what, you know, I think is one of the most problematic elements of our system, where the very system that separates, surveils, destroys families, right? We're choosing between Marty's nominations of a way to refer to this system, is also the system that is tasked with preventing the need for removal and also with remedying what the causes were of the removal and reunifying a family and being a service provider. And that the Child Welfare Agency has succeeded in large part because there is this perception about how the Child Welfare Agency is a helping agency. And so many people go into social work school and end up getting, you know, the job they can get in the Child Welfare Agency, thinking that that's a way to help families, right? So I was trying to depict that. I guess I'm seeing that some people see that, and it's not just in my mind that of the Rorschach test. But indeed, parents are the underdogs and government holds the power, agencies threatening families' power imbalance, parents being eaten alive by the entire system, department holding down my clients so the system can eat them. It does seem as though we are handing up our clients for consumption by the beast.
Wow.
I feel like I am blocking snakes all day, every day. So what are the challenges of child protective agencies providing reunification services and reasonable efforts and active efforts to families? What are the benefits of it? Folks could speak to that. One thing that I've been wondering, that this makes me think about, I'll just sort of speak out there and hopefully other folks will chime in, is how not trauma informed this our child welfare system is. That the notion that parents are supposed to trust the system that has ripped their children from them, and that parents are then supposed to figure out how to be vulnerable or just be vulnerable, because obviously you can't meet any effective service needs if the person is not genuinely sharing what's going on for them and what their challenges are. And so, you know, that's one of the challenges that I see, as well as whether or not the agency, in light of that threat that they always hold over the parent, are even in the best position to really be providing that support. And at the same time, this has been one of the biggest legal protections that we have had to work with. So we may not want to throw the baby out with the bathwater, and what might be benefits that we need to make sure that we keep in mind, so that we're not just expecting should we not just be expecting the Child Welfare Agency to just own up and say, we're a policing agency, that's what we are, we don't actually help families, is the softening of the system of some benefit by them being required to do more rehabilitative work with parents. So I just offer up those questions. The services are behavior modification services, not hard resources like housing and cash assistance. Funding is a challenge. Trauma-informed representation. The court process is also trauma-inducing. Absolutely. I wish we applied active efforts to all cases, but also go above active efforts. So some folks see that there are benefits to it. What are the benefits that you see? Double-edged sword. Workers in the system seeking compliance with services is one of the challenges. Rather than truly trying to help them, workers using information they learned about parents from services against the parents. So that's where we see that this helping model is not actually working, and perhaps that is by design, or the way that the structure actually is. Perhaps that's not a thing we can change. Sheldon, do you see anything to comment on from these?
We need to change the department's thought process to focus on the benefits of active efforts rather than just checking the boxes. I like what you were saying about, I think there is kind of this, and we talk about colonization, the whole aspect of colonization is a paternal act, is an up-down act. I feel like when I'm at my best as a parent, it's when I'm given self-determination. And I feel like when I'm doing my best work, it's actually meeting families and providing them self-determination, and being able to articulate what they're saying to the powers that be. And so I feel like those are some big things that I feel like I'm at my best when I'm at that. So when I have that,
So I want to read that benefits are that workers might actually do their job. So if we think about how fully funded our child welfare agencies are, by the, and indeed some agencies have very high caseloads and that kind of thing, but indeed that there is a tremendous amount of funding that goes to workers, and so wouldn't it be good to maximize that resource so that families actually do get help? The benefits of really trying to make this work. All right, so, but I also do see a lot of this stuff about how it's really not working, right? And so it's more about how the agency looks, it's more about compliance, it's more about monitoring families in the course of providing reasonable efforts, and then using any mistakes against them, right? So the difficulty trusting a system to actually be an adequate and fair or neutral service provider. Which is arguably what good case management really requires, and compassion. So who else would do that, and how? I'm going to move on because we want to get to more discussion, but just want to kind of leave that question hanging. And just note that also our organizations have often been filling this gap and often without funding to do so. So just a note about that. And that one of the things that we say to potential funders is that the only way parents are going to be able to really trust the help is if it's within their protected and confidential lawyer's office, where we're actually 100% on their side. But also there's a lot of challenges with setting ourselves up to be any sort of case managers or super service providers. So that's a dicey area too, but who else would? All right, so a number of, I just did this slide in case that there was like radio silence, but people have already kind of pointed out a lot of these points. So how has this dangerous mischaracterization of child welfare agencies as helping agencies who can remedy child maltreatment and reunify families effectively and meet families' needs, how has that infected the law, right? And so we see that basically that is how we have the reasonable and active effort standard, right? Because there is this notion that while agencies are regulating families, they are also helping families. But as many of your comments pointed out, that compliance is valued over improved family safety or actual wellness. It's more about how things look. And also that the child welfare agency is not designed or funded or trained to actually eliminate or alleviate the conditions of poverty. So we see housing lists being given to parents without actual assistance with parents about removing the barriers to public housing or subsidized housing. We're often the ones who are helping parents get back in school and get employment, right, which is going to do much more for their family long term than taking an anger management or parenting skills class. CPS is not designed to wrap families in a strengths-based supportive provision of services that would be responsive to actual needs. So it's not really following like the standard social work practices or guidance about how to create effective behavior change. Effective behavior change comes from people believing in our capacity to do something, not through punitive measures and in terms of carrot and stick approaches. It's not in line with what we know about what actually leads to human transformation when there is a need for human transformation. So also, the difficulty for families being vulnerable. So I don't know if there's any more comments that have come in, Sheldon, that would be good to point out.
There's a good conversation with the point that you're talking about compliance. I felt like that's a good point right there, just how the emphasis has been on compliance, and COVID has definitely disrupted a lot of services and how our clients access services and quote unquote comply.
Yep. We're calling the child welfare system social workers when that's not what they're doing. I just want to also lift up this comment. This seems like the same nut to crack as the criminal justice system has faced. Police should not be service providers. All right, so let's move on to the next one. Next item for thought. So what paradigm do we introduce instead? What is the proper role for agencies to be held accountable for? So if we could just take a moment and lift ourselves out of our current experience and imagine, and maybe there is a helpful comparison there too. We don't expect police officers to provide services to the families where maybe some harm has occurred, or maybe the police have created the harm. Are there things we could borrow from that system to reimagine what the role for agencies would be, and what would we want to hold agencies accountable for? And what should be the recourse if they don't do so? So I think about how in California, a tool in our toolbox is that if the agency doesn't file the initial petition within 48 hours, business hours of removing a child from home, the case is automatically dismissed, right? I mean, obviously they can then go back and refile it, but the case is dismissed. The kid should go home. And so are there ways that we could also, and let's, maybe say if it's too much of an imaginative jump to imagine something completely different, even just thinking about what are the consequences in criminal court for police tampering with evidence, violating Miranda rights, et cetera. And how might we borrow from other systems and areas where we see accountability and introduce standards in this system that would actually protect parents from violation by the system? I'm wondering if there's any comments coming in. This is interesting. Sometimes parents do not trust their attorneys in CPS cases as much as they do their attorneys in criminal cases. If they would, their attorneys could do more from them. George, I'm wondering if you're willing to say any more about that, or if other people have seen that pattern too, if you could explore what that might be about. Because again, we want to make sure that this conversation is grounded in us and how we are doing in the process of challenging the system and reinventing moving away from white supremacy culture, actually decolonizing and actually introducing new ways. So if there's other comments about how parents, what's going on there with parents not trusting their attorneys in our cases, have folks seen that, and what works in regard to that as well? Oh, I want to also lift up this comment. I feel the need to say that the social workers in my jurisdiction are good, caring, and hardworking people who do their best with the resources and funding they are provided. I'm not a social worker. I'm a parent's attorney. Perhaps my jurisdiction is rare, but we have a wonderful team in our court that works hard on behalf of the families to reunite them. We must remember the parents did things that caused removal, and thus it's understandable for courts to be very cautious when reuniting. I appreciate the balance that this comment brings, Linda, to the conversation. And again, I think this goes to this element of not necessarily, not necessarily abandoning the things that could be working better in this system as it is, and making sure that we are really working with what we have while we also keep our eye on reform. And I think you're speaking to situations where there may need to be some reparation, where there has been harm, sometimes caused by parents, and that, having a restorative approach is really important. And it sounds like you're saying that you do see some social workers acting in that vein, which is really great to hear. I do want to just sort of pose the question about the universal, like, it's not all parents have done things that necessarily caused harm or cause the removal. So I think we also want to kind of think again about the structural factors. And so, when we are looking at cases that have to do with ultimately at the root conditions of poverty and systemic racism, how do we shift the system to look at those? And perhaps some of the question is about how to introduce a reasonable effort standard that indeed does go to remedying those structural factors. And can we be doing more in our advocacy to identify what those racist and discriminatory and poverty-based structures have been that have made families' lives so hard? And so that's some of the creative narrative work about painting a picture of what the family has been dealing with, and how really the way to really help that family would be to, address criminal records, right? Or make sure that a family is supported through an arrest or incarceration, and that systemic structural factors are not interpreted as individual fault. And how can we do that in our advocacy as well? So Sheldon, are there other comments coming in that you want to highlight? Perjury laws, because social workers lie a lot. So that's another counter perspective around social workers. And indeed that there's going to be a wide variety of how social workers are acting in our cases. Yeah.
I like the comment about white supremacy. I like the comment about trust and how oftentimes or sometimes attorneys are seen as part of the system, so attorney-client trust, that's a big comment right there. And I think when we're thinking about out-of-the-box representation, out-of-the-box dynamics, sometimes it's not. Like I think we need to be out of the box if we are going to decolonize this system. It's probably not going to be through. I don't know. It has to be more that it's through the human aspect of this is what it's through. It's through the human. A lot of comments. I like the early comments about humanity. I think those are, when we have humanity, we have recognition of peoples, we have recognition of connection, and that's where it starts. And that what builds relationships of trust as well. So
Yeah. And also in terms of legal standard improvements, I want to, and creative thinking, I want to note Hope's comment that if we really made the system prove their case without hearsay and other evidence, it would make everyone work harder. And so that might be an area for legislative reform and also for bringing up the challenges with hearsay evidence in our appeals. So back to this issue about parents not trusting attorneys in this system. Parents think we are in cahoots with CPS, or that we are paid by the state because we are public defenders, right? I mean, public defenders have also had this problem too, right? So we're not alone. They all think we're part of the system. You know, and I also want to speak to the reality, back to the initial answers around what do you need? Resources, right? And if folks are just trying to keep their head above water and move from one case to the next, that can be challenging to really mount significant defense, and for parents to be able to see the intention and wish of a parent's attorney to be able to continue to challenge and you know, transform the system. That takes resources to do. I mean, I think there's also this sort of nonprofit thinking that we think we're supposed to be able to be superhuman on scarce resources, right? And so much of this is also about us building our organizational funding and infrastructure so that people can actually mount a fight. No small feat to do that. Changing the burden of proof standard, right? So getting it above, getting us above the standards that we currently have, which are so problematic. So evidence that is not allowed, that would never be allowed in criminal context. Also, pointing out part of the systemic issue around attorneys not having the resources, salaries based on how many cases we have. There's an incentive to be overworked.
That's a good comment.
Mm-hmm. Oh, interesting idea. More liberal discovery for background information for caseworkers. Have they previously testified? Background information. Similar to the pitch-us motion in criminal. I pronounced it wrong. Because CPS and the attorneys and the judge are all state employees, clients think we're on the same side. Yeah. And we may look like the CPS and the judges too. I mean, a lot of this is about trust when we're part of the dominant group. Has the caseworker been on a case where the department was previously sanctioned? So being able to look at the history of that worker. I mean, definitely we have workers where there's these reputations, right? What if that could be relevant? That's an interesting point in the legal analysis and testimony. What if agencies came in with an attitude of how to preserve the family rather than gathering evidence for removal? Oh, here's an idea. One of the judges has started telling parents that attorneys don't work for CPS and are independent in terms of improving trust for the parents' attorneys with clients. Interesting. All right, anything else here?
No, I think
I appreciate how active this is for this. Folks are having a lot of conversations in the chat. Sorry, I didn't mean to interrupt you though.
No, I think there's some good comments in here.
Great. Okay. I want to be mindful of our time too. So I think we've got some good ideas flowing, and to aid in the creative thinking, I want to pass it back over to Sheldon to talk about some models of decolonizing types of reform that have actually been initiated by tribes.
And I'll be radical right here. So these are tribal courts right here. And like I said, I do a lot of work with tribal courts. And I think in that very vein, and I'll explicitly say it right now, I think some tribal courts, and I could mention Barrow, Alaska, looking at innovation that, do you know what, it's not lawyers that are going to solve that are going to empower families. This might not sound very popular, maybe not here, but it's not even a rights-based system. So it's not even a rights-based system that's going to solve these issues. These issues are more complex than that, than me arguing rights, me arguing burdens of proof, that talking circles, that healing circles, that are collaborative and not individual-based. And we can look at even styles of representation, you know, best interest representation, best interest representation that we have for children, and how that mucks things up in some royal ways when it comes to guardian ad litems and children's attorneys. And so we can kind of look at some of those dynamics. So there are some innovative things that are happening that are about proximity. I think another tool, you as an attorney, I think having, if you don't know about the safety guide, the ABA safety guide, I feel like that's a tool in your toolbox, being able to safety plan and frame that in that way to the court. And so that's some work that I've been a part of in the last 3 years, is training tribal advocates to safety plan and bring those plans into courts so children can stay safely with their families. Proximate to culture. If we go to the next one, customary adoption is worth mentioning. Of course, that's in tribal codes, but 2 states have adopted that now. Oregon, most recently, Oregon's adopted it, but it's in California as well, where there's not termination of parental rights. There's a little bit more humanity when we come into those types of cases with suspension of rights rather than termination of rights. If we go to the next one, and I'll aim to wrap up here. So I do work with ICWA courts. So there's about 20 ICWA courts throughout the country. This one up in St. Louis County, Duluth, Minnesota, Judge Tarnowski. If you look at this courtroom here, there's something unique. You can see it looks like a regular courtroom, but where she sits in this one, she arranges those, that approximates a circle right there is what she's trying to do right there. And she climbs off her bench and she sits at the level of everybody else. And they do have a talking circle. Everybody has the right to speak in this, even parents. Of course, she asks their attorney if it's okay, they speak, but she usually hears directly from the parents in these cases. If you look right in the center of that table there's medicines. So she works collaboratively with the tribes up there. And so they've all gifted her with medicines. And right now they're instituting this, it's in state code, the parallel protection process, where it is talking circle format. It's not adversarial. It is collaborative, of getting everybody on the same page, because in majority of these cases, we all know what the outcomes are right at the very beginning. We are trying to reunify this child safely with their parents. That's the goal. That's the goal of that everybody has. Of course, everybody else has these other agendas, but if we're able to square that away. The other thing unique about this area of law that's not like anything else is that, do you know what the evidence that between this hearing and the next hearing, we get to make it up. And I say that in the sense that so much changes from one hearing to the next hearing, you know, that the parents might get a job, you know, they might succeed in their treatment, you know, they might comply, you know, like they might not comply, you know, like there's so much that happens in between the hearings that we're going to have new evidence for the next hearing, you know, so much changes in between. So starting off from a strengths-based approach. And then the last slide, and I'll just wrap it up really quick with this. And there's a couple of quotes on here when we talk about colonization, but I'll tell you this, since we're talking about medicine, I know for me, at one point, and I'll make this, I come from a storytelling tradition, so I'm going to tell this really quick. I worked for the Ute Indian tribe based out of Utah, represented their children. I think there's another story in this about taking care of yourself. I had a high caseload, over 100 kids. I was burning out. I used to think in my mind that the best way to do this representation is work really hard. So I wasn't doing very much self-care, and it probably showed. So I was in tribal court one day. There was an elder in the back of the room, and he saw me. He must have took pity on me. It was a day like this, beautiful day, sun was shining. He's like, "Hey, can I take you out to lunch?" And I probably had dark spots around my eyes, and my shoulders were scrunched down. And I said, "Yeah, I could go for a sandwich." So we went and had a sandwich, and he told me this story, and it was medicine. It changed my paradigm and my approach to this work. And I'll share that medicine with you right now with his permission. He's given me permission to share this story. He asked me if I knew who Siach was. That's a Ute word. I'm like, "No, I don't know who that is." And he's like, "Well, it's the monster that steals children." You need to know the story if you're going to work in our community. So I'm Cheyenne. I was working in a Ute community. He says, okay, what is the story? And here's the story. Is a long time ago, there was this big monster, 7 foot tall, skinny, carried a basket on his shoulders. There's a little boy out by the reeds, by the river, by himself. And Siach jumps out, steals the little boy, puts him in his basket, and heads up to the mountains. It's a 2-day journey. The first night they set up camp, and all night long, the little boy that's in the basket, he cries. Horny toad, a horned toad. So if you live in the Southwest, there's horny toads all over there. Kind of have this arrowhead shaped body. Horned toad wiggled his head inside that wicker basket, and it's a good omen to see a horny toad for the Utes. He says, "Hey, nephew, what's the matter?" And the little boy, through his tears, says, "You know, I've been taken from my family. I'll never see my mom and dad ever again. I'll never eat my grandmother's cooking. I'll never hear my language spoken. Never play with my cousins. I'll never dance at the bear dance." And the horned toad cried with them. And he says, "I want to help you. I want to advocate for you. I want to help you." And the little boy reaches down in the dark and fills the horned toad. And he says, "You feel like an arrowhead." He says, "Yep, that's right." And so in the morning, Siach is going to come check on you. I want you to use me. I want to be a helper to you. And so in the morning, Siach comes and lifts up the basket, and little boy rises up in David-like fashion and throws the arrowhead into the heart of the beast. And he's able to escape to get home to his family. I know this work is hard. It'll burn you out. It'll break your heart. It's tough work. It feels like we're on the losing end all the time. We're spoken a broken will, actually, is what it feels like. I felt that. I felt defeated on many different levels. And I feel like we're at our very best when we're a tool in the hand of a family, tool in the hand of a child, connect them to community and connect them to culture in the ICWA sense. But everybody needs culture. Everybody needs that type of connection. So I know I'm at my very best as an advocate when I could do that, when I could couch my argument in that. And I could build that relationship of trust so I could listen to that. And so I'm proud to be at this conference with you, and it's such an honor to be here with you. And that's what I want to leave you with, that medicine. Is there anything else you want to leave with, Sabrina?
Just to deeply thank you all for the work that you're doing. You're in the struggle. We are in it together, and I hope that this also leads to more connection with some of you and some ideas about how to strengthen yourself moving forward. Thank you. Sorry we ran a little bit over time.
Sorry about
all right. Hope to see you all in person in a couple of years.